Good morning, Mr. Chair and members. I'm here today to present AB 229. First, I want to start off by making clear my intentions in introducing this bill. As those of us who've been around for a while in this region, we're familiar with the Smiley Martin mass shooting that was in Sacramento, and it really rocked the Capitol community. If AB 229 was the law, then that mass shooting would not have happened, and we'd have 6 people still alive today. When I initially introduced this bill, I wanted to pick the most egregious crimes that I considered violent and propose legislation to have them considered violent felonies. So this bill includes domestic violence, sexual assault, and human trafficking of a sexual nature. I would like to emphasize that the bill deals with human trafficking only of a sexual nature because the analysis on page 1 seems to indicate that it is all human trafficking, which it is not. And I know that this committee has considered legislation like that in the past, and I listen to what committee members say and make my bills according to that. After introduction, it was a piece in the San Francisco Chronicle that raised issues that I honestly had not thought of. I learned from the article how gun violence and mass shootings are connected to domestic violence. Since this time, I've become more educated on this topic. People in this building on both sides of the aisle have reached out to me to express interest in my bill, and when it passes out of committee, I expect to add co-authors. My goal of AB 229 in its current form has evolved to tackling the problem of gun violence from a different angle by classifying domestic violence as a violent crime and increasing penalties for the worst and most dangerous offender. I don't want to rehash statistics on domestic violence, which are scary to say the least, and we know it's prevalent in society. But let's talk about some of the information on how domestic violence is connected to mass shootings. Between 2014 and 2019, over 2/3 of all mass shootings, an event where 4 people died, not including the perpetrator, the shooter either had a history of domestic violence or killed at least one partner or family member. While mass shootings only account for 1% of firearm homicides, it is clear that the most likely people to commit mass shootings are those that commit domestic violence. So what my bill does is make felony domestic violence a violent felony. Misdemeanor domestic violence, which is a crime such as domestic battery, such as pushing someone away, often with no signs of physical injury. Felony domestic violence is violence resulting in bodily injury. There's also felony domestic violence with great bodily injury, which actually is a violent felony, broken bones, concussions, gunshot wounds, or burns. But what you'll hear about in a little bit in the case of Smiley Martin is that was not felony domestic violence with great bodily injury. But what is unbelievable is that a partner can be a constant victim of abuse, and as long as there are no broken bones or gunshot wounds, our criminal justice system does not consider it a violent felony. As I mentioned, my bill also includes human trafficking of a sexual variety, and just within the last few days, there was a major sting here in Sacramento. You'll read a lot of convictions of this crime can lead to sentences up to or sentences maybe, and usually they're long sentences that they can potentially be convicted under current law. But women can be trafficked into the sex trades, and there's an extremely wide latitude of penalties, but not considered violent. But why do these need to be considered violent felonies, you ask? Because under Proposition 57, since these crimes are considered nonviolent, those who traffic others for sex and those who that inflict injury on their partners are eligible for pre-sentencing credits and early release programs. So one of these 5, 10, 15-year sentences will be dramatically lower. This all comes together in the case of Smiley Martin, who committed the mass shooting right down the street, and 6 people died, had prior convictions of violent attacks on his girlfriend, and encouraged his girlfriend to work as a prostitute. But because neither of these crimes were considered violent, he spent less than half of his 10-year sentence and went on to kill 6 people. Let me read you an excerpt about him. This is from the Sacramento District Attorney. Less than 6 months later, inmate Martin forcibly entered his girlfriend's residence. He located her hiding in her bedroom closet and hit her repeatedly with a closed fist on the face, head, and body, causing visible injuries. He then dragged her out of the home by her hair to an awaiting car. After he put her in the car, he assaulted her with a belt. The victim had been working as a prostitute, and that inmate Martin had been assisting and encouraging her to be a prostitute, according to text messages from them. Martin pleaded guilty to 2 felony assault charges for a 10-year prison sentence. Had our laws considered this kind of violence to be a violent felony, at least 6 people would be alive right here in Sacramento, and this is just one case. Unfortunately, this case will go down as one of the statistics that the study referenced. Today, I have Alicia Berry from the Orange County District Attorney's Office to testify in support of the bill.
Good morning. Thank you, Chair and distinguished community members. My name is Alicia Berry, and I'm here on behalf of the Orange County District Attorney's Office and the California District Attorneys Association to urge a yes vote on AB 229. CDAA is pleased to support your measure that would add several forms of sexual assault, as well as human trafficking and domestic violence, to California's list of violent offenses in Penal Code Section 667.5. For too long, the law has minimized the violent nature of sexual assaults, rape, sodomy, oral copulation, and penetration in circumstances where the victim's resistance was overcome by any means other than brute force or threats of brute force. This has left victims who were drugged or attacked by persons in a position of power to endure a lesser form of justice than victims who experienced physical force or a threat of physical force. One example of this is Andrew Lester, who drugged multiple women into a state of unconsciousness before committing grievous rapes and other sexual assaults, often on videotape. Lester's victims were in grave peril due to the amount of potentially lethal drugs he administered, but because his victims were unconscious, his crimes were considered nonviolent. AB 229 would also include the sexual trafficking of human beings and domestic violence causing injury to the list of violent offenses. Both of these crimes disproportionately endanger women and children, and their addition to the list of violent felonies will help secure justice and ultimately safety for those vulnerable victims. And we believe this is a common sense measure that would recognize the violence perpetrated by means other than brutal force. For these reasons, CDAA supports AB 229 and appreciates very much your attention to this important issue.
Thank you. Are there any other witnesses in support?
Good morning, Mr. Chair and members. Corey Salzillo on behalf of the California State Sheriff's Association in support. Thank you.
Thank you, sir.
Greg Burt with the California Family Council in support.
Thank you.
Sophia Laurie with the California Family Council in support.
Pastor Brandon Campbell with the Faith Baptist Church, Wheatland, California, and Northern California, Director of the California Capital Connection for Baptist Churches in support.
Thank you, sir. Are there any witnesses in opposition?
Good morning, Mr. Chair and members. My name is Carmen Nicole Cox. I'm Director of Government Affairs at ACLU California Action, and we are respectfully opposed to AB 229, which intends to ratchet up the punishment for sexual assault, domestic violence, and human trafficking by relying on increased punishment rather than community investment. ACLU does not dispute that those who commit rape should be held accountable. As indicated in the committee analysis of this bill, all forms of rape are currently a serious felony, and sexual assault conviction is a felony, rape. Sexual assault seems to be more appropriate. Rape conviction is a felony punishable by up to 8 years in prison. Punishment for human trafficking for the purpose of specified sexual conduct is up to 20 years, and criminal penalties for domestic violence, even that doesn't involve great bodily injury, are up to 4 years. Each of these penalties can be enhanced under current law to include significant additional time in prison. And while more time in prison will respond to our rage, it will not have the effect of making survivors whole. Rape, human trafficking, and domestic violence survivors deserve to be believed, to have their cases solved, and to be treated with compassion and provided the services needed to address trauma and harm. Survivors should be empowered, not employed, as justification to undermine, for example, the will of the voters, most recently as expressed in November 2020, when they rejected Proposition 20. We understand that adding the specified crimes to the list of strike offenses will impact credit earning inside of prison, limiting the ability to earn release based on demonstrated commitment to self-improvement and rehabilitation. However, rehabilitation is precisely the outcome we want from incarceration. Otherwise, we're simply warehousing individuals. Notably, California already locks up a higher percentage of its people than almost any democracy on earth. And while prison overcrowding has not made our communities safer, it does result in inhumane prison conditions, cost taxpayers millions of dollars, stymies rehabilitation, expands the budget and footprint of the prison industrial complex, monopolizes resources that would be better used to invest in our communities in ways that would improve holistic health and create community prosperity. Consequently, we ask for your no vote on AB 229.
Thank you. Yes.
Hi, my name is Margot George, and I'm from the California Public Defenders Association. I would echo the comments of my colleague from the ACLU. We are in opposition to AB 229, and of course, although we are opposed to human trafficking of minors or adults and domestic violence, we believe that increasing penalties is a failed policy that has neither deterred crime nor prevented future victims. AB 229 does nothing to solve the underlying problems in our society which lead to sex trafficking or domestic violence. And we have research now and that tells us what we need to do. And I'm going to repeat some of what I said last year when this bill was here, a similar version. You had last year an informational hearing on sex trafficking, and you had the USC Gold School of Law researchers at that informational hearing, whose study found that the United States over-relied on law enforcement and a retributive criminal justice approach to address complex societal issues that instead require nuance and understanding of trauma, race, and poverty. They said effective anti-trafficking efforts are moving away from support for use of operations, focusing instead on community involvement, public health and harm reduction strategies, and investing in poverty relief, anti-discrimination initiatives, and opportunities for education and employment. And those recommendations and that research also applies to domestic violence. Their recommendations, most notably, were support community and public health approaches to identify victims and traffickers outside of the criminal justice system, redirect funding to evidence-based victim identification methods that are more effective and less harmful to victims. And to the extent that law enforcement operations continue, implement strict policies and trainings that increase the efficacy of victim identification while minimizing trauma to victims. Increase the transparency to support more effective oversight. Strengthen prevention efforts that reduce the vulnerability of potential victims. Increase services available to victims and systemically offer comprehensive services to every suspected victim. Improve communication between nonprofit service providers, prosecutors, and other law enforcement agencies, community organizations, and sex workers. And I would just say today, to wrap it up, thank you, is that today is Equal Pay Day. Today is the day in which women finally make as much money as men do at the beginning of the year. And one of the issues is the equality. The equality of women will really help change the situation and lead to fewer victims. For those reasons, we respectfully ask for your no vote on AB 229.
Thank you. Any other witnesses in opposition? Name and organization, please.
Brooke Hewley, Los Angeles Dependency Lawyers, in opposition.
Glenn Backus, Ella Baker Center for Human Rights, strongly opposed. Danica Rodarmel, Initiate Justice, and the San Francisco Public Defender in opposition.
Joshua Thubay, California Attorneys for Criminal Justice in opposition.
Jim Lindberg, Friends Committee on Legislation of California, opposed.
Thank you. Bring it back to committee members for any comments. Yes, Mr. Lackey.
First of all, thank you for this measure. You know, sex offenders are uniquely threatening, and to deny that is to deny fact. And I don't care what study, I don't care what other kind of justification is expressed. That is a fact. And what seems to be the prevalent trend in my observation the last several years is the victim consideration appears to be becoming abandoned. And why in the world would offenses like rape and other sexual assault of an unconscious victim, or rape and other sexual assault of a victim who is too drugged or intoxicated to give valid consent, why in the world are those not considered violent? It defies logic to me. And so this is just a common sense plea for victims. So I'm clearly in support. If I'm not a co-author, I need to be.
Thank you. Any other comments?
Yeah, I
Mr. Zuber.
hesitate to wade in here, but you know, one of the problems I have with this bill is there's a lot of plays with, you know, use of words, you know, related to violence, and it leads to the impression that we don't have strong and harsh penalties for crimes related to sexual assault. I looked at the bill analysis, and there's, I think, 3 pages of very harsh penalties that are already in place. And you would think from the bill analysis that none of that is in place, including, and this was actually news to me, the one strike sex law, which provides 15 years to life imprisonment for basically rape with any aggravating, with a whole host of aggravating factors. So to me, the problem I have with this bill is it leads to the incorrect impression that there are no penalties for what you described as being the most heinous crimes out there. There are extreme penalties out there. Anything that I think is a violent act, not only are there the underlying penalties that I think the witnesses talked about, but in most of those cases, there's going to be aggravating penalties that are added on top of that, and most defendants are facing very, very high potential penalties. So I don't think this is needed. I don't think, I don't appreciate bringing these kinds of bills forward that lead to false impressions about the penalties that are out there, and lead to the impression that folks that are committing violent acts and violent sexual acts are sort of getting off scot-free. So I won't be supporting this bill today.
Thank you. Any more comment, Mr. Alanis?
Yes. Would you have anything to come back on as an answer or reply to those?
Yeah, I mean, well, thank you for those comments, and thank you for asking that. Yeah, I think the reality is that, as I mentioned in my statement, is a lot of the 3 pages. First of all, a lot of the pages aren't or not a lot. Some of them are not relevant because it's talking about if something is actually charged with a violent crime, for example, with the great bodily injury example. But I just gave an example of a very heinous crime that occurred right here locally, where that person might have been eligible for up to, but the fact is this person was convicted for 10 years, got out in less than 5, and then just went out and committed a mass shooting right here in town. And the data does actually show that domestic violence, people convicted of domestic violence are the most likely people to commit mass shootings. And so I think as we talk about ways that we're going to prevent mass shootings and things like that, the only thing we're only talking about one side or the other side of the equation. It's been a constant fight in this building for as long as I've been around, which has been 20 years now. And it's the same argument. Nothing ever changes in the state level or the national level. So I'm bringing a proposal here where, yes, it is possible that people are charged for a long time who commit violent domestic violence, but that is not what's happening. And I gave a very public example of that not occurring. And I think for somebody that's going to drag a woman out by her hair, beat her with a belt, and punch her in the face, I do think that that is a violent crime and should be charged as such.
Yes, Mr. Ryan.
So what's appropriate? You get charged as a domestic violence. You get sentenced to 10 years. You serve 5. You come home. If 10, there would have been no shooting. 15, no shooting. 20, no shooting. Just life. Drag you out, hit you with a belt, life in prison forever. I'm just trying to understand what argument you're making here.
Sure. Well, you know, with Proposition 57, you get your release date from prison the day you walk into prison. The day you walk into prison, you get your release date now, as of the new regulations from CDCR. Rehabilitation is not a part of that.
Respectfully,
so
I'm asking how much time should that person have had to not then commit a mass shooting, since that's the crux of your argument?
Well,
5 years wasn't long enough,
sure.
so I'm wondering what is the appropriate amount of time?
Well, since we're talking about this specific case, I can guarantee you that this would not have been performed in Sacramento. These 6 lives would still be here if
he had done 10 years.
Correct. Yeah, 100%.
I think that's absolutely ludicrous, and we'll be voting no as well.
Okay, thank you. Any other comments? You may close, Mr. Patterson.
Sure. Well, thank you so much. I just want to address some of the statements that were made by the opposition here. In almost every public safety bill in opposition, I've seen comments about this isn't going to deter crime. Well, surely this would deter crime. Surely we know that Smiley Martin would not have been out of prison. We know that he would not have committed a mass shooting. And so, yeah, it doesn't bring the victims whole if this law were to pass. If this law was the law 2 years ago, there would be no victims. And so I think it's also, this would have prevented the future crimes. And also I want to correct, we don't currently have, Mr. Chairman, we sit in budget sub 5. We've had now 2 days, unfortunately I had to miss yesterday's hearing thanks to other hearings that were going on that day, and I'm sorry I missed it, but we've heard the testimony from the LAO that we don't currently have prison overcrowding. And I think it's a misstatement. We're at 105% of the population. When I started working here, we were over 150%, and people were on bunks. That is not the case anymore. We're talking about closing prisons. And I think we have to stop with the same old rhetoric. I am 100% in support of rehabilitation programs. Let's fund them. Let's work together. Let's do it. I'm on that committee. I'd be happy to work with you. But also, if we can deter mass shootings, if we can deter somebody from grabbing their partner out from their car and punching her in the face and beating her with a belt, and actually hold that person accountable so they don't subsequently commit a mass shooting, I'm all for it, and I hope you are too. I ask for your aye vote.
Okay. And so you said something, and I just want you to just kind of understand what you're kind of proposing is a back to the future kind of thing, where we did 3 strikes. That's how we got to overcrowding in the prisons. That's how we filled it with black and brown folk. And what you're proposing is a back to the future kind of thing. Like, if we just lock people up for a very long period of time, then they won't commit. You're right, they won't commit, as my colleague said, maybe for the 5 years. So is it 10 years? Is it 25? So if they come out after 10 years, you're going to be back here to say you need to keep them here for 15 years, for 20 years? That is not the solution. That's kind of what your bill is saying. The longer you lock people up, it will eliminate it. No, it may delay it, because inside the prison, if you don't give proper rehabilitation programs, which we agree on, then that person will just recommit that offense when they get out, or to be better criminals while they're in, and then get out, because the system at CDCR is broken. And so that's the dilemma you have right now with your bill. It's kind of you're resubmitting in a different, which is what one of my colleagues said, you're giving it a different look, or in a crasser way, you're putting lipstick on a pig. You're trying to say, if we go back to 3 strikes, we will stop all crime. We've already proven that doesn't work. We've already proven that. And that's what we're trying to let you know. The reason we can celebrate the fact that we don't have overcrowding is because we've implemented strategies and policies that wasn't about over-incarcerating, but doing more rehabilitation. Now, I will take you up on the challenge of how do we fix the rehabilitation, because it's, like I've said before, it's big C in corrections and CDCR and very small C in rehabilitation. And if you had been at that, I'm not giving, you had to go to the other committees, but if you had been at that hearing yesterday where we found out that 0.07% of the budget for CDCR is spent on rehabilitation, and 42% is spent on security.
Hey, don't get me started. We'll agree again.
So I'm just letting you know why there's a feeling with the majority of the people on this committee that 3 strikes is not the way to go. And so unfortunately, we have to recommend a no vote. But I do believe your heart's in the right place. So.
Well, I appreciate that, and I was going to say I like your tie today. Normally it's red, so, you know.
Is there a motion? I know there's a motion, and there's a second, yes. Madam Secretary, call the roll.
On AB 229 by Assemblymember Joe Patterson, the motion is due pass to the Appropriations Committee. Jones Sawyer.
No.
Jones Sawyer, no. Alanis.
Aye.
Alanis, aye. Bonta. Bonta, no. Bryan.
No.
Bryan, no. Lackey. Lackey, aye. Ortega. Ortega, no. Santiago. Santiago, no. Zabur. Zabur, no.
I'm sorry, that measure fails.
Thank you.
Thanks for bringing